Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer. This series is entitled Buying Tenant-Occupied Property in a Just Cause State. And for this series, I will be joined by Kaitlyn Jackson. She's a lawyer with Williams Kastner in Seattle. Kaitlyn, would you tell us a little bit about yourself?
Sure. Yes, my name is Kaitlyn Jackson. I'm an attorney. I practice landlord-tenant law and general real estate litigation with Williams Kastner based out of Seattle. I have been doing a lot of landlord-tenant law since about 2018, and I'm also a board member for the Rental Housing Association of Washington.
This first episode, we are going to talk about seller leasebacks. So when a buyer purchases property, and the seller wants to retain possession after closing for however long, what does a buyer and a buyer broker need to be aware of? And actually, what does a seller need to be aware of from the standpoint that a seller may make the property less marketable if the seller demands to retain post-closing possession? So I'm going to lay a little foundation here, and then I'm going to let Kaitlyn tell you what some of the risks are that aren't necessarily going to be anticipated by brokers without a little bit more information. You may remember that within the last year or so, the law in Washington was modified so that when a seller retains possession after closing, it is possible for the buyer and seller at the state law level to create a scenario where seller's retained possession is not subject to the Landlord-Tenant Act. There's 3 criteria that have to be met in order for that to be true. The property cannot be a distressed property. The seller must have been represented by a real estate broker or a lawyer during the negotiations or the closing. And the buyer may accept rent for no more than 3 months following closing, and the time of possession for seller's post-closing possession based on the agreement between the parties can exceed no more than 3 months. So let me say that third criteria one more time, say it a little differently, maybe a little clearer. When the post-closing agreement is written, seller's possession can be no more than 3 months after closing, and buyer can accept rent from seller for no more than those 3 months after closing. Is it that simple, Kaitlyn?
Of course not. Thanks for letting me elaborate on this. So one of the biggest changes that happened in landlord-tenant law happened in 2021 when the legislature passed statewide just cause. Now, what that means, we'll call it good cause because they don't actually use the term just, but what that means is that anytime there's any tenant occupying a property, whether they were a previous owner of a sale or just a traditional landlord-tenant relationship, a family member, anytime they occupied it, in order to terminate that agreement, there needed to be some sort of good cause that was approved by the state and had the associated timelines with that. So for example, if there was an intention of the owner to sell the property, and the tenancy needed to be terminated, and it was month to month, the landlord needs to give 90 days notice to terminate that tenancy to sell the single family property.
Based on state law.
Based on state law. So there's a whole list of things in this statute of what is good cause, what are the timelines. Now, one of the problems that came up from that was that when properties were actually occupied by a seller who needed a seller leaseback for a very brief period of time sometimes, just in order to allow them to relocate, well, the state law didn't create a very clear cause for how that relationship could be exempted from traditional landlord-tenant laws. So as you know, last year, the state did step in and say, well, there's an exemption from this cause or from this requirement or from these laws if it is a seller leaseback after the seller has sold the property, if it meets these criteria. Now, the issue that has since then been created is that the local ordinances, we're talking the cities, the municipalities, the counties, they also have their own additional landlord-tenant laws that sometimes are even more expansive than the states, or oftentimes they are more expansive than the states, which don't speak to the same sort of exemption of a leaseback from a seller. And so these are considerations that a seller might need to make or a buyer might need to make when they're deciding whether or not this is an appropriate situation for that arrangement to be made.
Okay, so hang on a second. So our statewide form lease agreement intended, or rental agreement intended for this purpose, created recognizing the state law criteria, those three criteria, right?
Yep.
The form that brokers are intended to use. What you're saying is that even if a broker uses that form properly and properly counsels their buyer as to state law, that state law may not be what controls. It may be that even if they try to get that seller out based on state law, they may be unable to do so based on local law. Is that what you're saying?
I am saying that, but I am saying two different things. One is these are new laws. And as any lawyer knows, when new laws come into existence, how those laws are interpreted also has to be fleshed out from a legal standpoint, sometimes going up to the United States Supreme Court. So in interpreting how these this new statewide or state form that brokers use is used in the context of a local ordinance that doesn't create that exemption, it's still legally unknown. And so there's a risk there that comes with it. Now, I know that there are some local ordinances that are very clearly much more broadly applied to what is considered a tenant protected by their local tenant ordinances. I know there are certain cities that I'm pretty clear as an attorney, that's going to become an issue if it ever
so there are some cities and counties that you already know that if a buyer / landlord after closing tries to remove a seller / tenant based on state law, there are already cities and counties. You're aware of local jurisdictions that would already say you cannot remove this seller, even though state law would allow you to do so, and even though you drafted the contract based on state law. You're saying there are locals?
Yes.
Can you tell us which local ordinances those are?
Let's take Federal Way, for example. Federal Way has a local ordinance. I don't remember what the legal term they've used for it, but it is a tenant act that defines tenant much more broadly than our state law does. And I believe that it is any person occupying a property as a residence. It does not require that there is any sort of agreement between the parties for them to occupy it. It doesn't require rent. And therefore, that argument under Federal Way would be that even though the state may exempt this relationship from the protections of the landlord-tenant good cause actions and the requirements, Federal Way's ordinance is read much more broadly. And I have actually witnessed in court the arguments being made that if it's more broadly to protect these type of occupants, that is what is going to govern. And whether that's made it up to the Supreme Court, it has not yet, but maybe it will in the future. My hope is that it's never my client that is on it's involved in that.
Okay, so Federal Way is an example of one local jurisdiction where if the seller retains possession and the buyer broker did a good job of advising the buyer about the risks of seller occupying post-closing. And so we've got to really conform to what the statewide form for this purpose says, and we've got to make sure that we're 3 months or less. In Federal Way, that still wouldn't protect the buyer tenant, right?
Probably not if it were challenged. And backing that up a step, we just talked about between the relationship and the agreement at the broker level between the buyer and the seller. But if you read again, using Federal Way as an example, the person protected is any person occupying a property as a residence. So any person that the buyer or that the seller maybe has invited to live in the property with them that isn't subject to that agreement, they are protected. So it is very, very broadly applied.
Okay. So can you give us a list of all of the local jurisdictions that are impacted?
No, they change all the time. I feel like every couple months, another city either implements their own, starts their own, or amends their own. Because it's not just about did they pass something, it's have they passed something new.
So what advice would you give to a buyer then, a buyer broker, as they're contemplating allowing a seller to retain possession anywhere in the state?
Well, I would be asking that person to consider making sure that they get the advice of an attorney that is very familiar with that very particular city or county's laws with regard to that. And it's not just about the city or the county's laws and the state laws, but it's also about what does that court system look like as well. An example of that would be if you are moving through the court system in Thurston County, things are going to move much faster than if you're in King County. King County right now, if I have to move forward with an unlawful detainer because somebody has not removed themselves from a property after the expiration of their agreement or in violation of their agreement, it takes me 7 months just to get a court case right now, just to get a hearing, just the first hearing. So that's a very different conversation from somebody down in Thurston County where I can get one in a couple weeks.
Okay. So here's the takeaway that I'm picking up from this. If you are a buyer or a buyer broker and the seller is demanding, let's start with the overarching goal is always that you, buyer brokers, that you create a purchase and sale agreement where possession is exchanged on the date of closing. If you can make that happen, that's your number one priority with respect to this issue. If that's just impossible for some reason, if seller is demanding and buyer wants to purchase even with seller retaining possession after closing, then buyer brokers and buyers, you should be seeking legal counsel. Buyer brokers, you should be advising buyers to seek legal counsel. Buyers should be talking to their own lawyer who is familiar not only with state law as it relates to landlord-tenant, but the local law where this property is located, the local law as it relates to landlord-tenant law. Because otherwise, buyer, you may buy property believing that the seller will be out in 3 days or 3 weeks or even as long as 3 months, only to find out when that date passes and seller hasn't moved that you now cannot get them out in any reasonable amount of time or for an affordable cost because you are in the throes of an eviction action that you had not anticipated. Is that right?
That's about right. And I also think you could go a little bit further in making sure that when you do close, if possession is supposed to change hands right on the date of closing, making sure that the property actually is vacant before the money is transferred, because there are even circumstances where that has become a little bit of an issue.
And that's a lot more challenging.
Yeah.
That's a lot more challenging.
From a practice
I think there is also a message to sellers in this conversation, however. Sellers, you could be decreasing the marketability of your property if you insist that a buyer take the risk that a buyer takes based on all of the things that Kaitlyn has just described. Not only the state law, good cause requirements, but any additional criteria or difficulties imposed by local law and local court systems as they interpret local and state law. So sellers, if you want to require that a buyer grant you post-closing possession, just recognize that could impair the marketability of your property. And if it makes sense to find a different solution, then you might want to see if that is in fact an option. If you have questions on this topic or any other, please visit WARealtor.org. Ask your question. Thank you for being a Washington REALTORS member.